Good afternoon, everybody. My name is Tammy Alvarez. I'm from the Fort Lauderdale Chapter of ABOTA. On behalf of Rebecca Brock, our president of FLABOTA, and our chapter, we would like to welcome everybody to this program. This program is practical aspects of the new and revised Florida Rules of Civil Procedure and is being broadcast in conjunction with FLABOTA and its Scales of Justice and Legal Education series. We have an amazing panel for you today. First to my right, we have our current administrative judge here in the 17th Judicial Circuit, Judge Carol Lisa Phillips. She has been on the bench since 2003. She has spent countless hours with her colleagues working on our current CMOs and UTOs. She's going to be discussing those here with us today. And most likely, she's going to be our next chief judge here in the 17th Judicial Circuit. To her right, we have Kara Link. Kara is an appellate attorney, a graduate from Stetson University, 1994. She has clerked for the 4th DCA. Her practice encompasses over 30 years. She now does statewide civil appeals for both plaintiffs and defendants. And for the past 20 years, she has been involved with teaching and supporting professionalism endeavors to our members of the Florida Bar. And last but not least, we have Paul Regensdorf, who is a graduate of Vanderbilt University. He started his legal career clerking, in the 5th Circuit of Court of Appeals. For the past 52 years, he has been involved in civil and appellate practice. He has been on numerous committees, and he is currently on the Civil Procedures Rules Committee. He has led the committee's work that has led us to the adoption of the current federal-like rules. So before we begin today, I just have a couple of announcements that I'd like to cover. The first one, due to the overwhelming response that we have had to this seminar, we have over 3,000 people that are currently on with us today, and that is our capacity. As a result, we are now recording this, which is going to be available to those of you who are not able to stay for the full 2 hours, or to those of you who are not able to log in. So what I would ask is those of you who are in, if you have any colleagues that call you, or if you could reach out to them, if they're not able to get in, let them know that they can go to the Fort Lauderdale ABOTA website on Monday, and we will have instructions on how they can watch this. We have been approved by the Florida Bar for 2.5 CLEs, which is great. They have also approved us for 1/2 of a CLE for ethics/professionalism. The last thing I'd like to say is I would encourage everybody to submit their questions early, and there should be a website that is on the bottom of your screen. If it's not, the website for questions or the email address is abotaftl@gmail.com. We would like to address the questions as they come in as our speakers are talking today. And for those of you who get questions in, we hope to get to all of the questions before the end of the seminar today. So Paul, why don't you go ahead and start us out with a little bit of background and an overview of what we can expect today.
Thanks, Tammy. Again, I'd like to add my thanks to that of Tammy's for the ABOTA work and the Broward chapter for putting this on, along with the Broward County Bar Association, who has graciously allowed us to use their facilities. And again, thanks to Mitch Chester from the local chapter, who has set this up and has had to grow with this class as we went from 100 people signing up to 200 to 500 to 1,000, and now to over 6,000 members of the Florida Bar and judges signing up. I'm sorry we can't accommodate all of them. We simply could not add capacity quickly enough. There will be an available recording of this, though. Check the FLABOTA site or the Broward Bar site in the near future, and we will notify those of you who could not join. Of course, I'm preaching to the choir because they're not here, but those of you who could not join, we should be able to watch this at that point on the internet. Folks, this is probably the largest change in the rules, in the civil rules, certainly in the general approach to how cases are going to be managed since these rules were adopted 58 years ago. I wasn't there at the beginning, but I was there pretty close to it. And this change is a sea change. With the degree of the important material that we have, and with at least 3,000 people on this call, we can expect a bunch of questions. Tammy said we're going to try to get to them all during this session. I doubt that we'll do that, but we're going to do our very best. But if we can't get to them, we'll try to group them together into common questions and put out some kind of a written joint response on the same website so that those of you whose questions don't get addressed will get some kind of response. That's how important this question is. Again, the address for the questions is ABOTA FTL, ABOTA FTL at gmail.com. Don't use the chat feature. It's not being monitored to this. So let's get to the basics. How many of you have heard that these changes are going to be the worst freaking thing that has ever happened to your practice and to your judicial division? How many of you have heard that's going to be the worst thing ever? Raise your hands out there. Okay, I'm counting. I get to almost 29,000, almost 3,000 people have agreed with me. Well, let me tell you this. It's not just going to be that bad. It's going to be worse. We're all going to die. It's going to be horrible. What? I'm sorry. Tammy says I got the wrong script. So we'll try that again. Now, what's going to happen, folks? Answer, nobody knows for sure, but let's say this. There will certainly be hiccups. There will certainly be some larger problems locally from time to time, without question. But we're going to get through this together as a judicial system with the lawyers and the judges. I urge each of you right now, before we get into the detailed rules, to print out the rules. If you're near a computer with a printer right now, have them in front of you as you go through this seminar, because they're gonna help you weather this storm for the next several months and probably for the longest time. There's two big parts to the sets of rules. One is a case management piece, which is really what got this started, and that is that the courts have tried to find a way to take the control over these cases back from lawyers who used to drive the bus and decide when cases would be noticed for trial or not, and they turned it over to the judges. That's the first big piece, and Judge Phillips is going to go into that in some detail. But there's a second piece that I think for lawyers may be as interesting or important. That's discovery that's been changed. And for that, we've got Kara here who's going to give us a detailed description of those changes. So please get your rules out and take a look at them. This case management concept that we're going to be moving into is really not that much different than what's happened in the past. In the past, lawyers would sit around on a case for 6 to 8 months. Someone would finally notice it for trial, and the judge would issue a trial order with all kinds of scheduling details. Well, think about it as though the plaintiff's lawyer was required to file a notice for trial, which there is no such thing anymore, but be ready for trial on day one. And when that case was filed, the court promptly serves a case management order establishing all those same deadlines. That's what we have. So we've cut out that period of time at the very beginning of the case where things got up to speed, and you're then given a typical period of 18 months to get rid of the case and conclude it. So is it changed? Sure. Is the focus different? Right. Have the judges attempted to take control of this? You bet they have. Will they succeed? I hope so. So what I think you'll find in these is that there's a lot of federal rule flavor in these rules. That's generally a good idea. One of the problems we're going to face, however, as you all know, is that the federal courts have law clerks, they have magistrates, the magistrates have law clerks, they have case managers, they have far fewer cases, and they tend to have larger law firms working for them. So we're gonna have some growing pains as we get into these rules because they require more work on judges and some more work on the attorneys. By the way, these rules have started being developed back in 2019 before COVID, because the courts thought the system was overloaded with cases. They needed to move them along. That set of rules has finally come to fruition into the rules that went into effect January 1st of this year, January 2025. But there's a wealth of materials. If you need to research what happened, there's some tremendous research written up in the reports from the work group, from the civil rules committees and others before the Supreme Court. It's a bit of a tough class to teach for us because what the rules have done is they've taken the statewide set of rules, which used to control everything pretty much, and have turned it over to the local circuit judges who have, under the control of their chief judge, issued centralized case management orders that are going to control practice in each of the 20 circuits. That was really started back in the COVID era. It worked pretty well because of the differences in how courts handled COVID. Now we're not really in a COVID period anymore, but they've kept that concept. So we now have a decentralized system, which is not a good thing, but in each individual circuit, it's an efficient thing. because each court can set its own rules. The problem for the practitioner is if you practice in more than one court, you're going to be stuck because you're going to have to learn the case management orders, the trial orders, and how they set them up in each of those. What we've done is we've selected Judge Phillips, who's the chief, going to be the chief, and who helped to develop this rule in Broward. They have a very detailed and complex implementing order. And when she teaches you how she has gone on with the 17th Circuit, you'll be able to see and help evaluate your own circuit rules in the various circuits. Two things to keep in mind that will make this system work. One, two words, and some people don't like them. One is professionalism. The lawyers need to remember that we're in a profession and act so. And secondly, in my opinion, I may have some disagreement on this, judges need to remember that they still have discretion. They're not cut off from all discretion just because they've been told to take control. So think of it this way: if your opponent calls you and you don't call him or her back, what does that say about you as a lawyer? If the judge called you, you'd call that judge back promptly. So what this system needs is for you to treat your fellow professional lawyers as you would if the judge were trying to get a hold of you in a particular case. Respond, coordinate, get these things set up. Now, there have been some glitches, and we'll identify some of them here today, and we'll find more. But as you, the lawyers in Florida, practicing in Florida, find these glitches, please help us out. Let me give you an email address. Or actually, it is an email address at the Florida Bar. It's called rules, RULES, at FLABAR, FLABAR.org. If you think you have found a problem with the rules, a glitch, something that doesn't work with something else, please identify it to the bar, to the Civil Rules Committee. We'll address it. Put a title of the rule, of what rule you're talking about in your subject line, and send it to rules@flabar.org. It'll really help us out. Okay, again, that's how you raise questions. For today, questions for the panel, send to abotaftl@gmail.com. Again, the seminar is being recorded, and we'll post that location for where it's going to be posted shortly. Also, Mitch Chester at the end of this will be trying to compile a report, which we'll also publish and circulate to give you something in writing. Hopefully that gives you an introduction to this seminar. I think it's going to be extremely helpful to you lawyers. I hope it is. Tammy, back to you.
Thank you very much for that introduction, Paul. Judge Phillips, I believe that would be a great segue into speaking about the case management orders and the uniform trial orders that you and your colleagues have come up with for the 17th.
All right, I will try to do my best. And what I'm going to try to do is, since we have so many, we have the 20 circuits within the state, and we have so many folks on here this afternoon, I'm going to try to give an overview of what it's like for all of us within the state, and then kind of give examples out of the 17th Judicial Circuit. So first of all, as Paul said, I want to thank all of you for being here today. I want to thank you for this prestigious panel that I'm sitting on. Just as Paul talked about and Tammy talked about how long we've been in practice, it's over 100 years of experience up here. It's kind of, Anyway, we'll move on from that. I want to thank FLABOTA, Florida ABOTA, as well as our local Fort Lauderdale ABOTA, who is putting this on today, the Broward County Bar Association, which has been invaluable. And if you saw this setup here today, it's wonderful. And I want to thank Broward County Bar and Braulio and his son Anthony, who is always the leader in the technology of recording us. All the paralegals, legal assistants that are on today, the judicial assistants, the lawyers, and all of the judges. Thank you for being here. This is the first step, and it's a huge point of progress in being successful and moving forward with these new rules. So the new rules were amended and finalized just on December 5th of 2024. So just a little over a month ago. And remember, December is that holiday month, so lots of people are also on vacation. They became effective on January 1st. In between all of that, all of the circuits throughout Florida had to be ready to go on January 1st. And it takes a whole lot of effort by all of the circuit civil judges, at least within my circuit, to get this up and running. We literally had to change the system, prepared new case management orders, new uniform trial orders in compliance with the rules, and reset orders that comply for all the judges to then review, give comments, recommendations in the civil capacity. And just remember, we have 16 judges that are in some capacity work in civil. We have the general judges, and then we have complex litigation, foreclosure, and then we have a judge who has about 20 cases within his division. And I would be remiss if I didn't thank our technology department. Our IT department is fantastic. And I know many of the circuits probably feel the same way about their technology departments. They have and are working hard to get us up to speed. We are currently working on automation. We are adding templates daily, and we have uploaded the new case management order, as well as we're getting the uniform trial order uploaded. So with that, as Paul said earlier, if you didn't print out the rules and have with you, if you're technological savvy and you have the two screens on your desk in front of you, pull them up on the screen and let's talk about them. Paul also said that be professional, and if you had a judge calling you, you would pick up that phone. I don't know, Paul. I've been put on hold when making phone calls. I've had my phone call dropped. I've had, they'll call you back sometime in the future. But anyway, everybody just take a deep breath, sit back, relax, take notes if you wish, have the rules in your hand, have the rules up on your screen. Yes, the rules have changed and we will go through in detail, but please remember where we have been in the past. And again, Paul hit a little bit about this, that this all started in 2019, but it's hard to forget 2020. And with the courthouse in-person closures, the rules and the way we practice law dramatically and immediately changed, literally overnight. We learned Zoom. We learned to do Zoom. We learned to do evidentiary hearings, bench trials, even jury trials. We learned how to upload documents. We learned how to share screen. You all did depositions, and you still do via Zoom. Witnesses live during jury trials are common now via Zoom, and we kept the case counts at the same or even lower. Then we thought we had it made. We thought we had jumped the biggest hurdle in our lives, but 2021 came along, and 2021 brought big changes in case management that went from that, both of us agree on a continuance, judge, can you continue the case, to strict deadlines, firm trial dates. The 17th had the 6-month trial blitz. I'm sure all the attorneys who practice here remember that. That was from October of 2021 through March of 2022, with 150 cases on each judge's docket. We all survived, and we learned a lot from the process, and it dramatically reduced the jury trial backlog from 2020. Then came 2023. We thought, oh my goodness, our case counts are down. Life is good. We're working hard. We're having case management conferences. But no, 2023 brought tort reform change, and that was another hurdle. But we jumped over it. And even with that, the thousands, and in South Florida, it wasn't just thousands, it was tens of thousands of cases filed from Miami-Dade through Palm Beach County. We ended the year with the help of the professionalism and the preparedness of all counsels involved and the hard work of all of our judges. We ended up in 2022 with the same and lower case counts throughout South Florida. So please be patient with one another, be professional, communicate. Communication is very important and is required by these rules. And most importantly, whatever you do and in whatever circuits you practice, if you don't take anything more than these 4 things away today. Number 1, review the administrative order for that circuit. And the 17th Judicial Circuit, it's right on our website. Number 2, review. You must do this, these 4 things. review the case management order and the uniform trial order. We in the 17th Circuit, we flipped it because the rules required it. So now the case management order is about 11 pages long, and the uniform trial order is like 2.5 pages long. So it's flipped. As you all know, the uniform trial order used to be 10 pages long. Now it's the case management order that comes out within that first 120 days. That is the long order, and then the uniform trial order follows that up. So learn it, memorize it, and if you do not have some type of tickler system, which I cannot imagine that you do not have, because I haven't practiced law in more than 2 decades, and back then we even had a tickler system. But if you do not, create one, purchase one. And AI, I've been to multiple different seminars on AI, and AI has some great attorney dashboards for calendaring. And for the least technological advanced folks out there, the ones that hate technology, at least get one of those wall-size calendars that you can put up there and remind yourselves. Number 3, review and keep handy the new rules. As Paul said, print them out, bring them up, know these new rules. Number 4, review the judge's policies and procedures. Every judge within the state of Florida is required to have policies and procedures posted on their website. So even though we strive for uniformity, we're all constitutional officers. We all have likes and dislikes. Please review. If you're in front of Judge Phillips on tomorrow morning, review her policies and procedures. Those are my policies and procedures, but review my policies and procedures. Review the AO, CMOs, UTOs, and again, keep the new rules handy, memorize them, know them. They're your friends, get to know them. Now, Kara and Paul are going to go through the new rules, but from a judge's perspective, I want to go through and hit on them, and then we're all kind of going to jump in and talk about them. So, we as judges must comply with these rules as well. And if you have read them, and again, we all urge you to read them and know them, these rules, most of these rules require some form of sanctions in many instances of noncompliance. It's not a may, it's not discretionary. It says must throughout the new rules. But it also says that there is discretion upon the judge on what type of sanction should occur. And then we have been discussing it. We've been discussing it amongst us as judges. We had a meeting last Wednesday, and amongst the panel on our meetings, what does that really mean, and what can the sanctions be? Because if you read the new rules, the old rules did not allow for dismissal, and there were many reversals dismissing a case for non-attendance at case management. But now the rule says it may be dismissed. Well, does it still require causal factors? Again, we had a meeting, and the type of sanction is discretionary, but it has to be proportionate to the non-compliance. And again, we had a meeting in the 17th Judicial Circuit last week, and we discussed, again, a learning curve, giving some leeway, especially in the beginning of these new rules. In the beginning of January 2025. It's my belief, just like in the past when we've had things dramatically change, in the middle, by the middle or the end of the year, everybody's going to be compliant, and we hope for compliance, but it's going to be in the rearview mirror. It's going to be like old school. And if you don't know them, you're going to get left behind, and you are going to be sanctioned. And those sanctions can lead to dismissal, which you do not want to have that discussion with your client. So again, for example, on a first noncompliance, let's say you missed a deadline. We've discussed that one of the sanctions may be to watch one of these seminars, whether it be this seminar over again that's being recorded, or many of the other seminars that are being done on these new rules. That may be the first sanction. And then the sanctions will get tougher as we go along. So there's a multitude of other seminars which you can watch, but disclosure experts, if you look at the new rule, it can require striking of that expert, that witness, that document when deadlines are missed and not done, and if you haven't disclosed them appropriately. There's also a new conferral requirement. And really, this isn't new in the 17th Judicial Circuit. Our notices of hearing have always required that you have conferred in good faith with your opposing counsel. Whether that's done, a lot of times we learn in motion calendar that it's not done. And for that reason alone now, the new rules require it. And now if you look at the new rule 1.202, before even the filing of a motion, you must confer with your opposing counsel. You must make a good faith attempt to confer with them. What is good faith? What is reasonable? Now, each of the judges may have a different idea, and that's why you review their policies and procedures. But just remember, non-compliance alone of that conferral requirement and the specific language that the rule requires you to put in your motion with regards to that conferral requirement is an easy denial by judges because you failed to comply. So what does the good faith effort mean? And again, we had a meeting about this, and you can read the policies and procedures of each judge because somebody may have a little bit of different perspective. My perspective is 2 attempts of reaching out to your opposing counsel, whether it be by email, text, picking up the telephone. I know that some judges indicated that they're going to require an actual picking up of the telephone and trying to contact the other side. And then if no response within 48 hours, you may file the motion. But again, you need to check the judge's policies and procedures. The other thing that's new, it's not new for complex, but it's new for all the general and streamlined cases. The case no longer needs to be at issue for the judge to set it for trial. So literally, we can file the case management orders and a uniform trial order with a firm trial date at the same time. The case no longer needs to be at issue. So for those of you who file those motions to dismiss and think, haha, we'll just let those sit and the judge can't set this case for trial, that doesn't work anymore. The case will be set for trial. It no longer needs to be at issue. Motions for summary judgment. Please review that. That rule has changed quite a bit as well, because not only must you file the motion, but if you receive the motion on the other end, you must respond to that motion within 40 days. And it no longer requires a hearing. And I know there's a lot of scuttlebutt about this and people discussing, well, they didn't mean to change that. If you look at the new rule, the word hearing does not appear in that rule. It discusses if a hearing is required, but there is no requirement for the judge to hold that hearing. And if you read our case management order in the 17th, we give you the prompts of what is required so we can rule on the papers if you wish for that to be ruled on the papers. Some judges may want a hearing on everything. Read the policies and procedures. The case management conferences are no longer required. There's no requirement to have them. Again, a lot of the judges will still want to have these, and we've discussed it, and some judges are going to be doing them further down the line to make sure that you have begun your discovery, that the initial disclosures have been completed, that you're moving forward, depositions have been scheduled, experts are starting to be disclosed, and so forth. But there's no requirement, as we've done here in the 17th since 2021, where it gets set within the first 120 days, because now all we have to do is issue that case management order. I can't stress it enough. The case management order and the uniform trial order and the policies and procedures and the rules are your legal Bibles if you do civil litigation. Continuances. This isn't the judge wanting to be tough, wanting to be difficult. This is the language from the rule. The rule says it went from firm and strict from 2021 to disfavored and rarely will be granted. And there has to be good cause shown. Please review Rule 1.460. The motion has specific requirements that we'll be going through with Paul and Kara. And if you don't comply, I guarantee you it will be denied. So one of the things that when I was writing this, it's comply or deny. And that's what a lot of the rules call for. So the 17th, this isn't something new. We've been pretty strict since 2021 about continuances. It's gotten a little bit even more strict. We're requiring good cause and you must follow the rule. And it requires your motion to be specific, that when you found out, it must be filed promptly and so forth. Review the rule, know the rule, comply or denied. Initial disclosures. Most people are saying, oh my goodness, in the federal courts, this is a requirement that has been in place forever, essentially. And they can be your friend. On the defense, also, I know that many of you on the defense side are saying, oh my goodness, what if I get this case out of the blue and nothing's ever been done and we don't know anything about this case until I get it in my hands? You must make reasonable efforts and disclose everything that you reasonably know within that 60 days of being served. And if you don't know, the rule requires that you supplement. And it has sanctions for not supplementing your discovery. And again, those sanctions can include in up to witnesses being stricken, experts being stricken, your documents not being admissible at trial or not being able to be used at trial. Again, sanctions for non-compliance, and some of these sanctions are non-discretionary. Proportionality, which you'll see throughout the administrative order that was issued by the Supreme Court. My thought, and pretty much everybody in the 17th, is if your case is in circuit civil, and it isn't an extremely streamlined matter, such as let's say a simple credit card debt from American Express or something like that, the standard rules would apply, standard interrogatory, standard RFPs, and so forth would be allowed at the least. And as the case gets tougher, obviously, different sets of interrogatories and so forth in order to try to narrow the issues. My hope is this seminar relieves some of the anxiety and stress of these new rules. We're not trying to make it worse. We're trying to help. We can do this. Remember, we are resilient. Is this a stressful time? You bet it is. Yes, we realize that. It's a stressful time for us as judges. Change is always difficult, but these are the rules. It may seem tough now, and we definitely will have bumps in the road, but we can do this, and we will do this. And in the end, again, as I said before, by the middle to the end of the year, it will be like 2020, 2021, and 2023. It will be in the rear view mirror behind us, and it'll be like we've always been doing it. The rules, again, they're not robotic, but good cause is required. You must follow the rules. Read and know the rules. Have a great tickler system and be always professional and communicate with each other. And with that, that's all I have from the judge's perspective.
We have gotten we've gotten quite a few questions in, and Judge Phillips, some of these pertain to initial disclosures. So I'd like to see if we can address them really quick before we move on to Kara. The first one is, can we serve our disclosures with the complaint, or do we have to wait until a notice of appearance is filed?
No, I would believe you could, of course you could file them with your complaint. That way your initial disclosure is done. The stress and anxiety and the tickler system of having to make sure you do it within the 60 days is complete. And I'm sure that the opposing counsel would appreciate that as well.
Definitely. Another one with respect to initial disclosures. If discovery has already occurred in a case, i.e. a case has been pending and we've already exchanged discovery, are initial disclosures still required under the rule?
No, and Kara, you may want to
Yes.
address that.
Sure. Thank you, Judge and Tammy. And so it's such a privilege to be here. Thank you to ABOTA's Fort Lauderdale chapter. Initial disclosures are the only aspect of the new rules that do not apply to old cases because the case has already been filed. So the 60-day clock it just can't apply. So the initial disclosure part is not applicable to pending cases, but every other aspect of these new rules are applicable.
Great. And Kara, I think that would be a great opportunity for you to go ahead and start discussing some of these new rules.
Okay, great. Well, I'm excited to be here and talk about discovery. There's so many positive takeaways based upon these amended rules. No longer will we have those 10-year-long cases that are pending. That's not going to exist anymore. For both plaintiffs and defendants, early discovery, as Judge Phillips just referenced, is going to be helpful. You are going to, on both sides of the case, be able to evaluate your case and help your clients achieve early resolution, much earlier than we've known in the past. More takeaways that are positive. The judges are empowered to report to the Florida Supreme Court for refinement. These rules are a work in progress. We are not done. And even the most recent opinion from the Supreme Court signals that point, that perhaps there are going to be amendments to the interrogatories in the future. For lawyers, as my colleague Paul reported at the beginning, we have an email for you to report to the Florida Civil Rules Committee for refinement. So I have a few slides that will help us learn these rules. If we could start. Thank you. I'm a visual learner. That's why we're hoping that
Me
you all,
too.
we hope you all have your rules in front of you, but in case you don't, we've got a few slides to use to help emphasize the points. Well, I'll go ahead and get started while we're working on the technology. The U.S. Supreme Court, Chief Justice Roberts, back in 2015, published his year-end report, and I thought it was so timely when I read it. The Federal Rule 26B1 had just been refined to crystallize what proportionality meant in discovery, and Chief Justice Roberts wrote that he can't believe that the members of our bar had a burning desire to spend their professional life wearing down each other with burdensome discovery requests or evading legitimate requests through dilatory tactics. That applies to us today, 10 years later. We're a decade later, but it's so applicable because we have our new rules have adopted the proportionality standard. The rules are designed, as Judge Phillips mentioned, completely agree. They're designed to make us communicate with each other, and that will elevate our professionalism. I love the picking up of the telephone. It is old-fashioned, but so often our tone is lost in emails. So whenever possible, pick up the phone. The discovery and the refinement of these rules are designed to avoid the gotchas and avoid one party outspending another party in discovery. Braulio, are we up on the PowerPoint? Oh, okay. So one point I want everyone to know is that the Supreme Court issued two opinions. It might be a little confusing, so I want to be clear. One was in May, one was in December. The May one, the appendix to that decision shows the bulk of the amendments to these new rules. And it's important to know where to find them because when you pick up the December decision, you'll see the refinement. And it won't have the red lines that were made back in May, and that can be confusing. So please make sure that you print both the May 23rd, 24 opinion as well as the December 5th, 2024 decision. In December, the Florida Supreme Court, after holding oral argument, receiving comments, and listening to all of you and judges, they tweaked, they revised the amended rules, made additional amendments to the proportionality and the discovery rules, and tried to avoid some potential inconsistencies. So let's start with Rule 1.280, because that's the general discovery rule. And I'm sorry that we don't have the PowerPoint, but we're working on it. And it will be online. I think we'll probably be able to post it on ABOTA's Fort Lauderdale online chapter. So Rule 1.280, as we talked about a little bit earlier, initial disclosures. This is first for us state practitioners, but in federal court, they have been doing this. It is very helpful. So we can go forward a few slides, Braulio. If you're, that's the two opinions. And here we are. Thank you so much. Scope has changed, right? We have the proportionality and we have a focus on claim or defense, not just subject matter. Timing is brand new, the 60 days we talked about, but there are more timing elements. Supplementing of responses. This one is near and dear to my heart because the Florida Rules of Civil Procedure have come in line with our ethical responsibilities and our professionalism obligations. So this is a consistent amendment with what we should have already been doing. It's not new. Signing of disclosures and discovery, that is new. We'll get to that. And then, of course, as you heard, we have sanctions. So the next slide really will detail Rule 1.280. The first issue I really want to just address is timing. We've already referenced, Judge Phillips mentioned the 60 days. This initial discovery disclosure is due. You are on a 60-day clock as soon as there's service of the complaint or joinder. And you do have a safety valve, but I don't suggest using it because I think it will only come up in rare circumstances where you have to seek a court order for some type of extension of that 60 days. The rules are designed to get things moving fast. So if you're the plaintiff, you have control of the 60 days. You're going to have all of your initial discovery or investigation done. And so as that first question that came in, can we serve our initial disclosure early? Do we have to do it, do we have to wait a certain time after service? No, send it out. Everybody's happy to get things moving fast. So 60 days is your clock. The tickler system, absolutely vital to you so that you avoid sanctions and malpractice, quite frankly. So you have to be careful. Now let's go back. What is that initial discovery disclosure? It's just your basic. You would know to do this if you were answering interrogatories. List the persons, individuals likely to have discoverable information, along with the subjects of that information. You have to give their telephone number, their address, their email address. And the only reason why you wouldn't disclose this within those 60 days is if the use would be solely for impeachment. That's it. It's limited. So when in doubt, send it out. Same holds true for the documents, a copy, send out a copy or description by category of the documents, including ESI. And again, same, the only caveat, the only exception is for impeachment. If you're not sure, send it out. You do not want to get caught with withholding evidence or withholding the name of an important person. And I'll get to an example of that. With regard to this initial discovery disclosure, it's not in the rule. It's really just a practice tip. I would suggest bait stamping at a minimum. If you don't have that technology in your office, if you're a solo practitioner and you say, Kara, I don't know what you're talking about, bait stamping, do an index, do something that is reference you can use later, because this initial discovery disclosure is important. You want to be able to show the court that you did comply. You want to be able to pinpoint what you did disclose. And so if you can't bait stamp, do some type of index at the top of your disclosure of documents. Don't do a dump. Don't do a discovery dump of large volumes of data and documents. So let's drop down to, and we're still on the same page here, subsection 4. Judge Phillips, did you have something?
I just wanted to, I know a few of you are wondering where you can find the rules easily. If you go to the Florida Bar website, at the top, it's my understanding, are the new rules.
Yes, thank you.
Thank you, Judge. Subsection 4, I call this the no excuses subsection of Rule 1.280. We have my husband and I love baseball, and our youngest played baseball for years on a team that we that we put together. And on the back of their jerseys, we had no excuses. And so when I read this section, I thought, yes, that's exactly what this is. You are not excused from this initial discovery disclosure simply because the other side didn't do it timely, or because you're challenging the other side's initial discovery disclosure, or because you haven't fully investigated the case. This subsection 4 is truly the no excuse subsection. You have to be ready if you're filing your lawsuit to provide this vital information that will allow the parties to assess the case and move it forward. If you are formally objecting to providing certain information, you also are not excused from a blanket objection. You can't just say the entire document that you're asking for that would be relevant is privileged just because there's some type of attorney-client privilege at the bottom or the top. You have to, this rule is clear that in making all the other initial discovery disclosures, you have to do it in a timely manner, and that which is not privileged, you must disclose. In addition to the names of individuals and the documents, another document that's really important, this initial discovery disclosure, is the policy. So for those defendants out there who are assigned a case by an insurance company, whether to represent the insurance company directly or you're representing the insured and you have the tri-party relationship, do your firm conflict check, and your first question should be, I need the claims file, and then I need a certified copy of the insurance policy, because you have to submit this. And there's really no reason why 60 days you can't get your policy out there. Let's talk about damages. So damages is really interesting subsection in this rule. This is really important because for the plaintiff, you have to know the value of your case. You have to give what you have in your possession that you use to compute each category of damages. The only category that is excluded is the non-economic damages, your pain and suffering. Obviously, can't quantify them. However, you have to list them, because if you read the exact words of this rule, the Supreme Court wants you to identify, even though it excludes non-economics, it says, but the party must identify categories of damages claimed and provide supporting documents. So my suggestion is to read this rule means if you have a pain and suffering category, you should list it. You're not going to be able to tell what that number or value is during the first 60 days. Or maybe you will, I don't know, but you're not required to. You're required to list every category of damages. So I think that discovery methods are all the same. Nothing has changed. You still have all the tools in your toolbox after you do your initial discovery disclosure. But what has changed is the scope of discovery, and this is significant. As we referenced earlier, and Judge Phillips did in her portion of this program, proportionality. So Florida has adopted the federal standard of proportionality in discovery. In subsection B1, you are able to obtain discovery regarding non-privileged relevant matters to any party's claim or defense. In the old days, it was subject matter, whether it was claim or defense. Subject matter is gone, and now we're very focused on claim or defense and proportional to the needs of the case. So the Supreme Court went in and adopted what the federal rules had clarified back in 2015, when I was talking about Chief Justice Roberts and his year-end report. And our rules explain, just as the federal rule 26B1 does, what proportionality means. And there are legs to this. You have to consider the importance of the issues in the action, the amount in controversy, the party's relative access to the information, the party's resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. That's a balancing test, right? Almost like a 90.403 balancing test embedded within this rule about burden, expense, and benefit. So if you look down, if we go to the next page of that PowerPoint, Braulio, please, on page 28 of the court's decision at the very top upper left-hand corner, you'll see the strikeout. All of that case law about reasonably calculated to lead to the discovery of admissible evidence, it's gone. It's stricken out. It's no longer our law. What is our law is that the scope of discovery need not be admissible in evidence to be discoverable. So that's consistent with what we've known. Obviously, discovery is a broader scope than admissibility. That has not changed. But the proportionality is a significant key. The Supreme Court is relying on the federal, I think they called it the old soil of federal case law when they referred to the amendment to the summary judgment rule 1.510. If we could skip just a few PowerPoint pages, you still have protective orders, but now that's perfect right there. So in May, to the left of the screen, you'll see what the Supreme Court issued in May. To the right is the refinement that came out in December. So the right is the final, but I wanted you to see how it changed because it is important. Sequence and timing of discovery, subsection E became subsection F in December, and they flipped the title. Timing came first. Timing. A party may not seek discovery from any source before that party's initial disclosure obligations are satisfied, except, and this is the December amendment or refinement, except when authorized by these rules, by stipulation, or by court order. Why did the Supreme Court make this tweak in December? Well, because we have a rule on interrogatories and requests to produce, and that has not been, well, it's been altered a little bit, but the timing has not been altered. Rule 1.340 and Rule 1.350 still allows you to send out with your summons and complaint that initial discovery. So that's why this amendment with regard to timing came out. But you can do all three. You can do your initial disclosure. There's no prohibition in the rules about waiting or holding back on your initial disclosure. So you can propound discovery with your initial service and summons of the complaint along with your initial disclosure if you want to do it that fast. Yes, Paul, you have a comment?
Just want to jump in while we're talking about this particular provision of F. Obviously, the rule intends, I think, that the court says no discovery until your disclosures are satisfied, unless authorized by these rules. Unfortunately, when you look not just at the interrogatory and request for production rule, but the discovery rule by deposition, by deposition on written questions, inspection of properties, request for admissions, all of them carry with them the implication of doing discovery with the initial complaint. So in the short run, if you want to do your disclosures immediately with your complaint, then you can also serve that initial discovery. But just to give everyone else the benefit, the Civil Rules Committee is already working on this glitch and intends to put into the various discovery rules, 350, 360, 340, a provision that says you cannot use these until you complete your disclosures. So disclosures have to come first or can come at the same time if you serve them with the complaint. So although it's not in the rule, I think it's clearly allowed that you can serve your full disclosure. But until you do that and satisfy your responsibility, you cannot institute any other discovery.
And-
That'll at least soon be the rule, I believe.
And Paul and Kara, that's great that we're discussing that because we have got a number of questions that have come in. Can I still serve, from plaintiff's attorneys, can I still serve my initial discovery with my complaint? So thank you.
Well, I think the explicit rule right now would say yes, because the rules allow the initial
Right.
discovery. But the Supreme Court, I don't believe, intended that. So I believe that, and we're going to try to amend it to say that all of those initial discovery things, which plaintiffs frequently do, again, interrogatories, discovery, requests for admission, interrogatories, all of those things, deposition notices served with the complaint are technically allowed right now. But I think the rule suggests no. There's going to be a glitch bill going to the Supreme Court quickly, which the Supreme Court will either approve or not. That will clarify that question. Right now, technically, you can do it. I think the rule suggests you should not.
We are clearly a work in progress.
No question.
And I think from the initial disclosure is supposed to try to narrow and not require as much discovery upfront. And you should be learning really from the initial disclosures what you would learn in interrogatories and requests to produce. So hopefully it will cut down on the expenses a little bit. I think that's probably a lot of what they were intending.
Absolutely. And to require thoughtful discovery. So, as a plaintiff, yes, you can still. However, you might want to wait for the initial disclosure and then propound thoughtful, tailored, proportionate discovery as opposed to you can still do the form standard interrogatories approved by the Florida Supreme Court, but you might want to tailor them after you get your initial disclosure. So it is designed to be more targeted discovery, more thoughtful discovery, and strategic. So I think, do you have another question?
We have a couple more questions with respect to initial disclosures, and since we're talking about them, I
Sure.
figured now would be a great time. One question, are the initial disclosures only served or filed as well? Because obviously those of us in federal court who practice know that we only serve them, we do not file them. And I don't see the provision in our rules, in the new rules in Florida.
Well, the actual language of Rule 1.280A says that a party must, without waiving a discovery request, provide to the other parties the following initial discovery disclosures. It says provide.
Okay, so there
That's
is
the-
no service.
And it says provide to the other parties. The rule is not perfectly clear. The implication is it does not need to be filed. And consistent with discovery rules in the past, you don't flood the court with a bunch of raw discovery.
Right, and-
That makes sense.
And we do have a follow-up question to that, which came in, which is actually a very good question. Do we file something with the court, letting the court know that we have complied with the initial disclosures, a notice of compliance?
I don't believe that's required under the rule, but you know something? This entire new system is gaining confidence with the court, showing the court that you're following the rules. I don't think filing a notice of compliance is a bad idea at all, but
No, me
I'll
either.
check. I don't think it's required in the rule.
Yeah,
Yeah,
it's
I
not
don't either.
required. It's not required, but that's a good practice idea. Might be a better practice.
I agree.
So,
I agree.
right.
Thank you.
It's way better than the notice of unavailability
Oh, yeah.
that no longer means anything.
Anything.
And it never really did.
Sorry about that, Kara. I didn't mean to interrupt
no,
your
that's good.
presentation.
So if there are no other initial discovery, we still have protective orders. Not much has changed there. So let's go to the next slide, please, Braulio. And this is exciting because, as I mentioned earlier, I think, if we could go to the next slide, it is subsection G, supplementing responses, which is now consistent with our ethical obligations, our professionalism obligations. In the past, our Rule of Civil Procedure 1.280 said we had no duty to supplement responses. And that's in conflict with, which you'll see later, a rule regulating the Florida bar and a professionalism expectation. So the Florida Supreme Court amended this, and it's consistent with federal practice, federal rules of civil practice. And we now have when a party who has made either a disclosure or responded to a discovery request, then obtains additional information, you must, as Judge Phillips said earlier, this is one of those mandates. This is mandatory. It's not permissive. You must supplement or correct your disclosure or your response. How? In a timely manner. It's undefined by the rules what a timely manner would be. I would make a note of when you learned of it in case you're challenged later, because this is really important with regard to whether you're going to be able to use it or not. And we'll see that under the sanctions rule, Rule 1.380. But right now, you have a duty to supplement or correct your disclosure. That would be your initial discovery disclosure or any discovery responses in a timely manner. If you learn that in some material respect, it has to be material, that your prior disclosure or your prior discovery response was incomplete or inaccurate, or as ordered by the court may order you to do this.
One quick thought.
Yeah.
I've attended a couple of these seminars, and some, I think, incorrect information has been put out. Some people think that Rule 1.280, which includes the supplementation requirement now, does not start except for new cases filed after January 25th. That's not true. Rule 1.280 as presently written applies across the board in every respect to old cases except for initial disclosures. Meaning, if you've got 100 cases on your docket from last year and the year before, technically on January 1st, you have to go through all of that existing discovery that you've given and give additional supplementation if the other side doesn't already know it. There is a provision, I believe, in the supplementation rule that says if the other side knows about it. For example, if you learn something in a deposition and your opponent was there,
Right.
I don't believe you have to supplement that.
That's
But
correct.
the concept of supplementation is applicable to every case. I'm sorry to say that. Got to go back to all of your 100 cases you got right now, or at least within a reasonable period of time, and supplement it unless you can comfortably say the other side reasonably knows that fact.
Right. That's right. So it's a spring cleaning of your cases.
It's the
Look
spring
at your
cleaning rule.
Spring cleaning rule. Check your discovery responses. And as I said earlier, when in doubt, send it out because you're now under that January 1st effective date for supplementing a response. What you see now on your screen is the rule 1.280 subsection K, signing disclosures. The bulk of this was brand new in May, and then it was revised just slightly in December to include that initial discovery disclosure. But what does this mean? Every discovery under this rule and every discovery request, response, objection made by a party represented by an attorney must be signed by at least one attorney. And your signature must include your address, your email, your telephone number. Why is that? This is important. As you go to the next screen, you are certifying with your signature that to the best of your knowledge, information, and belief, after a reasonable inquiry, a term undefined, but we'll get there, that with respect to the disclosure, it's complete and correct at the time it's made. And with respect to discovery request or response or an objection, that it's consistent with these rules. It's warranted by the law or a good faith argument for the extension, modification, or change in the law. It's not you're not making that objection or the response for any improper purpose, such as what? A delay, that would be an improper purpose. These rules are designed to expedite, not delay. Or to needlessly increase the cost of litigation. That would not be a good purpose. So, and also the subsection C is really the proportionality rule said in a different manner. Not unreasonable or unduly burdensome or expensive, given the needs of the case, the discovery already had in the case, the amount of controversy, and the importance of issues at stake in the litigation. So let's stop and take a breath because there's a lot in that certification and it is a really important certification. Why? Because in December, the Supreme Court added to it. And what they added to it was a sanction aspect. And that's really important. So what's a reasonable inquiry? It's really not defined, but I think it's more than just asking, it's digging a little deeper when you speak with your client. If it leads you to speaking to another person, or if the client's corporate representative doesn't have the answers, you've got to go a little further. You can't just stop with one person if that person is not giving the information that you need to defend your claim or to prosecute your claim or defend your defense in the case. The teeth in this rule, they really come down to the bottom paragraph or the new paragraph, which is if a certification violates this rule without substantial justification, the court on its own or on motion by the other party can impose an appropriate sanction. Actually, let me restate that, Judge, because I misspoke. It's must impose, and that's the problem. This is what Judge Phillips mentioned earlier. There is no wiggle room. There's no discretion. There must be a sanction. If you certify your discovery is complete and accurate and you left out somebody or a witness or document, there's going to be a sanction. The question where the discussion comes in is what that sanction will be. The sanction may include an order to pay reasonable expenses, including attorney's fees that are caused by that violation, but the rule says must. So there's just really no wiggle room or discretion with regard to that.
Let me jump in. I hate sanctions as a means of regulating a profession. These rules sadly have more and more sanctions written into them, but this rule is an important one. Yes, the word must is present in there in the disclosure part, but it does say if the certification violates this rule, quote, without substantial justification. So with all due respect, judges, if you're listening, please, you first have to say, was there any reasonable justification, some substantial justification? Because if there was, that's why the disclosure didn't happen. Then there's no absolute necessity for sanctions. So when you look at these rules, read them, please, very, very carefully, judges and lawyers, because yes, the word must is there, but only after the qualifying term without substantial justification. And just to give you a heads up, there are other sanction rules very similar to this that are being proposed right now in the rules of general practice to e-filing, when you e-file something or when you sign something. I'm talking about any document, not just discovery, that sound very much like this. If those pass, we will soon be set against 3 conflicting or at least different sanction rules whenever we file something or sign something or submit a disclosure. So please, folks, try to avoid sanctions if at all costs. Read the rules, comply with them strictly.
So, thank you. Yes, substantial justification is going to be your friend if you have somehow made a misstep with regard to the discovery. The next slide just really is the overview of Rule 1.280, initial disclosures, and the scope has changed with regard to proportionality and the timing issue. Supplementing discovery, which is now our ongoing duty. The next slide, I just typed this up and showed just a chart for your initial discovery disclosure. It's not, there's so many different ways to skin the cat, so to speak, but here's a very simple way: the home or the name, the address, telephone, email, and then the subject matter or knowledge. Next, we're not going to do a document dump. We want to bait stamp or do some type of index. Next is the damages that we discussed. Next is the insurance policy. Next is the no excuse subsection. So just stay in your lane and focus on what you need to do. Don't be focused on, I'm not going to focus on Paul and what he has or hasn't done.
Which is a lot.
I'm going to be focused on my 60 days and what I need to gather so that I can timely comply with the rule. Because if Paul hasn't done it correctly, or I take some type of objection to his disclosure, that's not going to excuse me from being fulsome in mine.
And as we as judges often say in hearings, there's no self-help portion to be read in that rule.
Well said. So let's see, we're next. I'm going to skip through some of these because we've already gone over them. Timing and sequence we've done. One more, I think. Duty to supplement. Okay, so thank you. Now we're at I wanted to just touch on this briefly. Rules 1.340 and 350. They were changed, and they might, as Paul, you just heard from Paul, they might change again, so be alert. But the way they've changed right now is that the grounds for objecting to an interrogatory or request to produce must be with specificity, including the reasons. And if you don't raise a ground in a timely objection, that can be waived unless the court finds for good cause that you have an excuse for the failure to timely object. So what does this mean? Let's break it down. Judges should be able to rule on your objections on the papers. That's what this rule means. They want you to be specific. No more boilerplate objections. You can no longer say relevance and walk away from it. You have to say relevance. This is a breach of contract action involving lawn mowing services, and this interrogatory asks about the defendant's trip to Paris. It just doesn't have any relevance. So you have to give some just basic fundamental reasons for why you are listing that objection. And so I also want to say, if you have a case management conference, which should be your friend, I agree with Judge Phillips, those were excellent 4 takeaways of your friends that you listed. Uniform trial order, the AO, the CMO, your new rules, the judge's policies and procedures. I would add a 5th friend on your list, and that's your case management conference, because you can call that up, get some help if you need hearing time. You're stuck in and you want to push through because you want to comply with the timing and the rules. Call up a CMC. And so with these objections, this is something that could be handled at a CMC. The judge should be able to, list your issues, your pending issues, pending motions, and the judge can call up any of it except for summary judgments or something that is
Unless
requiring-
agreed,
And it's agreed, right?
unless they agree to it.
Unless they agree. Yeah, right. You could do a summary judgment if there's an agreement. So, but this is something that's really important because your objections can no longer be boilerplate. You have to give specificity. You have to include the reasons, and the judge should be able to look at your papers and say, oh, I get it. This is burdensome. Proportionality, applying that principle. This is a mom and pop supermarket. They don't have an IT department, and their daughter is their accountant after high school. She runs her books. So you can't ask for 10 years of financials, and it has to be proportionate. It's a slip and fall case. So that's really important. Paul, you have a comment on this?
I just want to jump in and tie 2 things together. Many lawyers in Florida are happy with the proportionality rule because I think it's going to limit discovery in a reasonable and meaningful way. Others, however, view it as an inappropriate sword that's been given to people to frame objections. Lawyers are already filing form objections, burdensome, overbroad, not proportionate to the case. Those objections are no longer valid. When we were writing this rule and this specific objection rule, the lawyers on the committee said, well, the objections need to be, including the proportionality objection, need to be with specificity. And we sent it to a group of judges, and that didn't even make them happy. They said, no, with specificity, including the reasons. Now, frankly, I'm not sure I understand the difference between specificity and reasons, but the way Kara just framed it, some of it was specific and some of it said why. So that's the objection that's necessary. If somebody throws you an overbroad, burdensome, or lack of proportionality objection, that is a sanctionable or at least inappropriate objection under this new rule. Specificity is now required with the reasons. Very important, tying the 2 together, proportionality and every other objection.
Also, Kara, and I don't know if you were going to touch on this also with regards to when you see these objections and there's a bunch of boilerplate objections, vague, ambiguous, overbroad, blah, blah, blah. However, we're attaching these documents or something to that effect. If you look at the new rule, it was my understanding also that you can't also just object, and if you make an objection, we're going to assume that you have some type of documents that are based upon that objection. Under Langston versus Allstate, which has been around forever, you have to say none.
Right. And that's a key. That's a very important, Judge. Thank you for mentioning that. That's very important.
I never thought that was even an important concept, but the number of lawyers who think it is, who write this long, detailed objection, and they don't even have any documents that fall into the objection. If you're going to make an objection like that, fine, but then you have to say at the end, and I have documents that fall within this category. Otherwise, you're wasting everybody's time.
Exactly. And if you ever sit through motion calendar on a daily basis, we see it.
I try not to, Jen.
So I have one last component of the discovery, and I know this is just the first of more lectures on this, but we wanted to try to cover as much as we could today. Bradley, if we could go to the next slide. Rule 1.380. This is the failure to make discovery in the sanctions rule. If a party fails to make a disclosure required under the initial disclosure or discovery, any other party may move to compel disclosure and for appropriate sanctions. I think Judge Phillips mentioned a motion to strike, a witness or a document. That's exactly what we're talking about here under subsection D. If you don't provide the information or identify a witness in the initial disclosure or supplementing the responses, you're not going to be allowed to use that information or witness at a motion or in a motion, a hearing, or at trial, unless the failure to disclose or respond with that information was substantially justified or is harmless. So I have highlighted these two terms because we heard before the substantially justified term, and now we hear harmless, and words do matter. The Supreme Court did not use the word prejudice. Binger would have triggered that concept. They used the word harmless. And so you may need to consider, if you find yourself in this situation of not disclosing a witness, not disclosing a document, you may need to consider an affidavit to justify why you didn't previously disclose it or why it's harmless. Paul mentioned, they were at a deposition. This name came up during the deposition. They knew about this witness. This is not a surprise, and it's kind of a so what. But be careful, because if you find yourself trying to oppose a summary judgment motion and you bringing in an affidavit of a witness or some person who has never before been disclosed, you're going to be in trouble with that. That is not going to be a good position to be in. But subsection 2 of this rule is my least favorite. Although it's existed for many years in the concept of spoliation of evidence, right? We have a jury instruction on it. So juries do hear about when a party behaves badly. And you'll see that this rule says if a party fails to provide, right? So it is designed to focus on the party. So the court can award reasonable expenses caused by the failure to timely disclose, can inform the jury of the party's failure, may impose other appropriate sanctions. So you just need to be really aware of this. And this underscores the need to supplement your discovery or initial disclosures. If we could go to a few more slides, I pulled out, we're not laboring under Binger with this issue. We are laboring under Special versus West Boca Medical Center, which is, we can stop there, Braulio, thank you. Special versus West Boca Medical Center, which is harmless, 59.041 under Florida statutes, harmless error statute. And harmless, when I think about it, it means it does not have a significant impact on the outcome of a case. It doesn't affect the party's rights in a meaningful way. You kind of say, so what? Okay. I didn't disclose this or didn't give it, but it's not harmful. It's like, so what? If you're using that as to oppose a summary judgment motion, it's not going to be harmless. It's not going to be a so what. So just be very careful. It's why the disclosures and supplementing disclosures are so vital to your practice as you proceed. And that's why the spring cleaning is so important. Going back to, when in doubt, send it out.
Let me, if I can, before you go on to the next topic, I want to keep us in time, but I've got 5 points to just highlight from Kara's absolutely excellent presentation on these things. There's a couple things that the Supreme Court said that I'm not sure how they're going to apply. Number one, they made a comment that the form interrogatories need to be reviewed under the proportionality standards. The Rules of Civil Procedure Committee has already looked at them. Those forms have stood the test of time for almost 20 years in small and large cases, and are not substantially too much or too little. That's been the test of 20 years of practice. So do not expect the Civil Rules Committee to recommend changing the form interrogatories, although the Supreme Court says you can challenge it. Number two, remember, folks, we're edging towards the federal practice system. When you're arguing these cases in front of the judge, you should use actively federal law. They have been using these new rules, our new rules, for many years, and there's cases, a lot of them, that you may be able to use to help your argument. Number three, if you don't know what a Bates number is, those of you who are younger than me, which is everyone on this call, in the old days, Bates number was a machine that you would stamp on a document. Every time you stamp, a number would change. So the first stamp would say 0001. Then second time would 0002. It was sequential numbering with a hand machine manufactured by the Bates Company. But folks, do that to your production. Kara is 100% right. There are computer programs that easily add sequential numbering to the pages, and you need to do that so that you can show what you got and what you sent to the other party. Critically important. Number 4, I think the comment at the beginning, I want to emphasize it. Right now, there's an issue as to whether you can serve initial discovery before you do disclosures because the rule is inconsistent. I think the best solution to that is, hey, plaintiff, get your initial disclosure ready, serve it with your initial complaint, and then serve whatever other discovery you want. And I think on that front, you're totally all right. But number 5, the last point is these rules, in my opinion, were not thought out in one point, and that is they talk about sanctioning sometimes the party, they talk about sanctioning the lawyer. I want to avoid lawyers and their clients getting into conflict situations. The rules are not clear as to who is going to be responsible for these excessive or at least new sanctions. So if you're that lawyer, make sure you've dealt with your client ahead of time. Make sure you put that into perhaps your client information letter talking about your cooperation will avoid sanctions, because there are going to be opportunities for conflict to arise when a sanction is ordered. And the question is, who's got to pay that, you or your client? And it may be totally your client's fault. The question is, if you haven't prepared it, you may be in a spot. So check the rule very carefully as to who the sanctions apply and deal with your client before those sanctions ever hit, because sanctions are going to be not uncommon. I hope they don't become common, but they're going to be not uncommon. Okay, that's it.
Kara, were you done with?
Yes.
Okay, great.
Yes.
Thank you. So Paul, I believe you were going to follow up with some other rule changes that we have had other than the discovery rule changes.
Yeah. All the exciting stuff is done. So if you need to take a lunch break, now's a good time. But let me run through.
No, don't go away.
Don't go away.
Okay, stay around. There's some other stuff that happened in these rules, and I think you guys should know about it. First of all, thank you for the original introduction. I didn't share the entire process of reviewing these rules. The Civil Rules Committee had a bunch of people, including the chairs for the last 3 years. Tom Edwards, Megan Luca, lots of people have been working on these rules, and because they need a lot of work. It's been a tremendously large job. Number 2, keep track, folks, because everyone, and I mean judges and lawyers alike, have been hearing all kinds of horrible war stories, and this is going to be terrible. And the point is, I don't think it has to be. The perception is it's going to really change our lives. I think the reality is that you and I and the judges who act properly, the judges who act with discretion, the lawyers who act professionally, will help us get through this with some hiccups, with some problems, but not with any massive difficulty. Don't let the perception of what you hear control your thinking in these cases. One question about the case management orders that the judge was talking about. Most of the orders that are eventually going to come out in the various circuits are more or less the same. They have to follow the format of Rule 1.200, but when they come out is different. The CMO in Broward is not going to come out with the complaint, but some courts, I believe, I've heard, are requiring a plaintiff to serve a case management type order, a form, with the complaint, or it will not be accepted for filing, or they will not grant a summons. I don't know if that's accurate, but if you are in one of those circuits, please check your local rules. I think there may be a serious access to courts problem if they limit your ability to file a complaint, stop a statute of limitations or a statute of repose because you didn't attach a CMO. But it's not so much that the orders are different, but different courts do it differently. Hillsborough County does them automatically on a computer. They've got a completely different system. Last point is the judge, and I'm sorry to tell you this, Judge, I told you before, and I think it's, at least it's my opinion, the fact that the rules now say judges can dismiss a case if you don't show up at a case management conference. Yes, it does say that, but I think if a judge exercises or wants to, the ultimate sanction of dismissal, which is what that is, I believe the Kozel factors, which are going to require more than simply non-attendance before you can dismiss it. I realize the rule says that a judge now has the authority to dismiss, but I believe if you're going to exercise the ultimate sanction, I think the case law under Kozel and its progeny say you've got to at least establish the degree of wantonness and reckless disregard, all the things that Cozell requires. That's my personal opinion. We'll see what the courts say. But now let's go on to the really exciting stuff, which are the rules that we've talked about some, but let me just touch base. The first is Rule 1.202. That's the meet and confer rule. We've talked about it. The judge talked about it. Kara's talked about it. Realize it applies to all motions in all cases, all motions with a footnote, almost filed after December 31st, 2024. It could be an old case, but the meet and confer requirement is applicable to that motion that you file in that old case. It's not just to new cases. It applies to all of them. So, and in fact, if it's an old motion and it still hasn't gotten to a hearing stage, why don't you go out and try to meet and confer before the hearing just to show the judge that you're trying to comply with these rules as a good lawyer? Show some professionalism. Reach out to the other lawyer for an old motion that's still pending and bring it up to date for the new rules. I think you're going to win some chips with the judges. As far as what you have to do to comply with the meet and confer, Rule 1.202 does not say exactly how many times or in what format. The judge indicated that Broward's going to use probably a 2-attempt standard. Some courts use 3. Some courts require 1 to be a phone call. I think the phone is a forgotten instrument in today's society. And as Kara so perfectly said, you lose the tone, you lose the emotion, you lose the humanity when you send a flat email. So sure, if you need to get their attention, do it, but do it with a phone call as well. All right. The rule applies to all non-dispositive motions. The Supreme Court struggled with that. They listed a couple of non-dispositive motions, which would be like a summary judgment motion, things like that. But that didn't make people happy. So the Civil Rules Committee wrote up a long list, which is generally all-inclusive, but take a look at it. There's a lot of motions that don't really fit a meet and confer requirement. And so those, like motions for default, motions for injunctions, judgment on the pleading, motions for summary judgment, probably are not going to be valuable to try on a meet and confer. My suggestion, though, is give it a try. Certify it anyway, not on the default, not on anything where you don't want them to know about it. Like, for example, if you're seeking a garnishment or something like that. But why not give it a try? One of the ones that they excluded was a 12B6 or a failure to state a claim type motion. I don't understand that at all, because there's a lot of 12B6 type dismissal motions where 3 of the counts are dismissed, 2 of the counts aren't. You can do that by agreement ahead of time. So I would give the other side a call for every motion to dismiss that I was filing. That's just my personal opinion. Again, it can be you can be sanctioned for this if you don't do it, and you can certainly lose your motion and have it dismissed or denied without prejudice. The rule says it doesn't apply if a party is unrepresented. That's either the movant or the other party, the receiving party. In my personal opinion, if I have a case against an unrepresented, self-represented party, I would at least try to give them a call and do the same. Give them the same courtesy that you give to the lawyer. You're not required to, but do that. They may not be required to call you, but you as a lawyer, you're the professional. Exercise professionalism. Call the other side. What do you do if you've got one unrepresented party and 10 other lawyers in the case? Well, my suggestion, you follow Rule 1.280. What 202? You have a meet and confer. Okay. Last suggestion on this: maintain a law. If you've got a lot of cases on your docket and they're routine, and you're talking to lawyers all the time trying to get motions scheduled, maintain a log in your office of every time you try to communicate with us. Teach your staff. If you've got a secretary, teach him or her what this rule is about. Same thing with your paralegals if you have them, associates if you have them, other partners in your office if they haven't been to this seminar. Keep track of these meet and confer things, because you are going to have to show good faith at every stage. If you want to get a continuance in 6 months or a year, you want the paper filed with all the things you did. Keep track, keep a log. Okay, I'm done with Rule 202, 1.202. Let me move on to a rule that maybe is a little more dear to your heart, and that's Rule 1.460, continuances. Okay, that's all I need to say about that, because that rule isn't in existence anymore. That's been written out, so I can skip that all. No. I don't mean that at all. Folks, there is still a continuance rule. It's 1.460. Nowhere in that rule does it say you cannot get a continuance. It says in the first paragraph A that this is really tough. This is really rare. But, that's been the case law written in cases, decisions for years. Courts still have discretion to grant continuances, but it is a continuance of a trial date. And I'll tell you what difference that means in just a minute. Realize that the first continuance rule proposed by the work group in 2021, after they've been working on it for 2 years, you couldn't have gotten a continuance no matter what. So this rule is incredibly soft and marshmallowy compared to that first rule. The rule is still there and it is still valid, if you will. And in terms of perception and reality, if you have trouble getting a continuance and you want to prepare for it, Kara gave me a wonderful clip. Go to the oral argument in November before the Supreme Court on this rule. Judge Moe, a circuit judge out of Tampa, made a cogent argument. She was like emotional and frustrated. She said, there's this rule 1.460 and everyone says, you're not going to be able to, I don't know why we have it. We're not going to be able to grant I can't grant a continuance anymore. And Justice Kennedy jumped down her throat nicely, but firmly, as is his wont sometimes. And he said, the rule doesn't say that. And he said these words, sooner or later, people are going to have to read these rules. A continuance is possible. It is available. The rule is there for a reason. You may not get it quite as often as you used to, but you can still get it. So my point is, the perception is you may not be able to get it. The reality is, in front of the right judge, if you've papered your file, there's a decision out of Gadsden County, admittedly before December 31, where a judge denied a continuance because the lawyers really hadn't done their job of showing that they've been really trying to work within the time rules. If you show that you've been trying to work within the 18-month scheduled rules or whatever the time frame is for your CMO, if you show the documentation, the judge, I've been working with this lawyer, maybe you've been working together. I don't know, but at least you can show that you've been working, documenting it, sending notices, sending emails, making phone calls, trying to work with them, trying to be professional. And now I can't get my case tried, plaintiff or defense. I want a continuance. If you bring that to the court has the ability, he or she, to grant you a continuance with discretion. So the rule spells forth what you have to give. You have to say the grounds, the specific grounds for your motion. You have to state the date you learned it, because you have to move promptly, just like with a disqualification of a judge. You can't sit on that. Once you learn about a DQ ground, you have to move to disqualify the judge. Same thing with the continuance. But do it. Paper the file and file it promptly. The basis when it became known, whether it is opposed or not. This is a gripe of mine, and now that I've said it, I'll say it again, and it will make no difference to any judge or lawyer in the world, but here is my gripe. We've got more cases than you could possibly get tried during any particular trial docket. If two good lawyers who have been working hard at a case come in and stipulate to a continuance, I don't mean slaggard lawyers who haven't been doing their job. If lawyers have been working hard and working on getting this case, but they can't get it done for a variety of reasons, they both stipulate. Their clients, the public, says, we want this case continued. Boy, I'll tell you, if I were a judge, I would be hard pressed to say, no, I'm going to force you to stand in line with the other 100 cases that are on my docket, even though we won't all get reached because the Supreme Court says 118 months and that's it. I hope there's discretion for cases when two good lawyers get together and stipulate. The courts are still the public's courts. They're not the judge's courts. They're the public's courts. And the public is represented as often as not by the lawyers. And if two good lawyers, professional lawyers who've documented their file, worked hard, come in and their clients want a continuance for whatever the reason, I urge the courts in the state of Florida to exercise discretion.
You mean for good cause reasons?
Well, that's the good cause. That's the good cause. And I know that Broward County, there's many of those judges who will do that. Okay.
As long as the rule is strictly complied with, and as you went through, that the basis is given and there is good cause shown, and it's stated with specificity, because as we all know that the judge now, if they do grant a continuance, must state the grounds and the basis of why they have granted that continuance and must reset that trial.
You think we practiced this or something, because that's exactly what I was going to go to next. But Judge Phillips, that's why she's chief judge. She anticipates the order number one, has to give the factual basis for the continuance, must set the new period, or either for the trial or set a case management conference. Doesn't have to set a new trial, but it has to set a case management conference. And it also has to explicitly say what will be allowed or not going forward. Will discovery be continued? Will only this one deposition be allowed? Will only the sick doctor be allowed to test? Whatever. It's got to be spelled out in the order. So that's all in Rule 1.460. Please take a look at it. And as the judge shall correctly point out, dot your I's, cross your T's, do what you're supposed to, act professionally. If we haven't been professionals yesterday, let's be professionals in 2025, and then the court system's going to work better. Here's one thought or strategy to keep in mind for continuances. I'm not saying it's a good one. The rule 1.200 allows the court at the very beginning to either set a trial period, an actual trial period or a trial date, or a projected trial period. And then sometime later during the case, that projected trial period gets converted to an actual trial period. Well, if your case has an actual trial date or an actual trial period already set, and you want to get it changed, you have to file a motion for continuance. You have to go through all that horrible subpart A, which says this is hard, you can't do it, it's strict, it's rare, blah, blah. All those things are against you, and you have to follow the form. But if you're still on a projected trial period, Rule 1.200E says you can move to extend the trial time, the projected trial time, by the provisions of Rule 1.200E. You still have to file a motion. You still have to say why. Some of the requirements are still there, but it is a less onerous way to get a continuance. That probably means you're going to have to identify those cases that aren't going to make it in 18 months earlier in the time period, maybe 6 or 8 months. Now, in Broward, unfortunately, our good chief judge to be elect in Coet, soon to be on deck, Judge Phillips, has written a rule that says all of the dates that they set are actual trial dates. So you can't use this little trick. But in many circuits, they're setting projected trial dates. And as long as it's still projected, you can use the extension time for 1.200E. Take a look at it. Summary judgments. Anybody interested in summary judgments? Well, there's been a small but important change in the filing and scheduling of summary judgments. It's simply this. But before, judges would get documents, motions, pleadings dumped on them or uploaded to their websites the day before, 2 days before a major summary judgment hearing. Totally unfair to the judge, and frankly, unfair to the lawyers to get the judge's intellectual brain working on this stuff. So the rule that was drafted in May and approved by the court in May of 2024 was not approved. That's not the rule to look at. That May order is not the order. It is the December 5th order on the summary judgment rule. That's case number 24662, I believe. Now, when you file first of all, you cannot file a motion unless you're in compliance with the case management order. That'll tell you your deadlines. They've got a last day to file, things of that sort. So you can't violate the case management order. But if you're within the times of a case management order, you can file a motion for summary judgment. The motion for summary judgment will give to the opposing party now 40 days to respond. Much like the federal system, which the response was keyed to the motion, now our system is also. A response is allowed or required if they want to file one within 40 days, 40 days. The hearing, however, cannot be set, whether it's set on day one along with the motion or set later, it cannot be set before 10 days after the response time or 50 days from the filing of the motion. Now, the response may not be in yet. They may choose not to file a response. That doesn't matter. A hearing cannot be noticed on that summary judgment motion until 10 days after the response is due, giving the judge at least 10 days to review the documents. Unfortunately, the rule still does not address either favorably or unfavorably the question of replies, which is another problem, and you only have 10 days now to deal with that. If you want to file a reply, there's no rule to help you with it. If you think it's important, file a motion, request leave of court, see what the court does. But that's the summary judgment rule. And the last rule that I have is almost unimportant, but I think you should read it. It's Rule 1.440. It used to be the rule that limited us to set cases for trial when it was at issue. And there were all these sorts of requirements and rules in there. That's gone. As Judge Phillips filled out for you with the 1.200 and the case management orders, they can schedule a trial date on day one, and they can under Rule 1.440. So take a look at it. I won't say it's an unnecessary rule, but there are some provisions there. But the basic concept of limiting cases being set, they're not there. We're running out of time, and I want to just touch on what's not in the rules very, very quickly. Believe it or not, there's no sanctions rule. There was originally going to be a sanctions rule. There should be a sanctions rule because we should be able to go to one place and have one standard. As Tara and the judge pointed out, there's all these sanctions rules, substantially compliance, all sorts of words, but there's not a standard rule. How can we live under a sanction rule when every single rule has a different sort of standard of what the level is, what you can or cannot do? And again, the rules of general practice are adding 2 more sanction rules that are going to be inconsistent. So there should be a rule much like 571051 is, but there isn't. It was not put in there. More importantly, and this really disappointed me, is I think the biggest problem we're going to have as lawyers going forward is getting appropriate time when we need it with judges. It's not the judge's fault. There's only so many hours in a day when a judge can commit to certain types of hearings, 845 simple motion hearings or longer hearings for summary judgments, and then try cases. There's only so many hours in the day. That's the choke point. What this system needs is a rule dealing with motions. How do you set them? How do you schedule them for hearing? What do you have to do, et cetera? It's not there. It was in the original proposal. We tried to submit an alternative to the court that hasn't been written. In my opinion, that's the choke point. How do you get around it? Well, you're not going to make more hours in the day or more judges, and you're not going to give the judges law clerks. But hopefully, with meet and confers, with professionalism, with dealing with the other lawyers like human beings, with honoring their phone calls to you and emails to you, even though it's a motion against you that you're not happy with, you can't avoid it by not returning that email. There's no excuse. If you're in trial, if you're on vacation, either you look at your emails every single day or have someone in your office look at your emails every single day. Check your voicemail every single day. There's no reason why calls are not returned every single day. Now, anyone who wants to look at my practice and say, well, Paul, you're not always the best at that, I plead guilty. I'm not. It's unprofessional every time. I don't do that. But I admit that at least I'm being unprofessional. Respond promptly to the judge, to the other side. This system can work, but only if the lawyers work at it as professionals. And in my opinion, if the judges realize that they are judges with discretion and are not simply automatons denying motions and granting sanctions. And I don't think they are. I have great respect for our judges. And I think the system can work. We're going to have some squeaks in the next 6 months, but we're going to get through this. And at the end, the system, I hope, will be better. And if you have comments, questions, or objections on rules, please send them to the Florida Bar, and we'll do our very best to tweak the rules and make them better tomorrow. Thank you.
Thank you, Paul. And I think that in the past hour and 45 minutes, we've heard a lot about professionalism woven in and out of these rules. And I know we want to touch on that briefly before we get to questions, but I need to apologize to the audience because we have over 300 questions that have come in, and we are clearly not going to get to all of them. So Kara, I'm going to turn it over to you for a few minutes to discuss professionalism before we get to questions.
Well, not to give short shrift to professionalism, but the questions are important. So we're going to skip ahead to a couple of slides.
And as I think Tammy said, we've been dealing and talking about professionalism the entire seminar.
Absolutely. Professionalism expectation number 2 pertains to honest and effective communication. And 2.10, a couple of slides forward, actually. Next one more. There we go. Thank you so much. I said earlier that we have been under the expectation and actually ethical obligation to immediately disclose or otherwise correct discovery when we learn of additional evidence. So this is, now it's codified in our amended rule of civil procedure, but we've always had this ethical duty to supplement or correct our disclosure. The next slide is expectation 3. We've always had the duty to be courteous and cooperate Now we're being required to communicate, which is excellent. We're not supposed to engage in delay or dilatory tactics, and we should not unreasonably oppose an adversary's motion, which is why that meet and confer is so important, because before someone files a motion, we have to pick up the phone or send an email and talk about it. It might be that you can agree to at least part of, if not the entire motion.
And just to jump in, these are on the Florida Bar website
Thank you.
also under professional expectations. And again, I printed them out way back in, I have the date I printed them out was 4/29/2022. So they've been around for at least a couple of years.
A long time, yes. And they are part of our professionalism code. In 2023, the Florida Supreme Court in July issued an opinion about these expectations and made them formally part of our professionalism code. Expectation 3, adhere at the same expectation, but the subparts talk about a lawyer only scheduling depositions to ascertain relevant facts, not to generate income or to harass your deponent or opposing counsel. Same with regard to pretrial disclosure, make reasonable good faith efforts to identify witnesses and exhibits. So now we have a rule that requires this, but we've had an expectation for many years in existence. Expectation number 4, fair and efficient administration of justice. If you drop down to number 8, I thought it was so interesting. 8 says a lawyer should frame reasonable discovery requests tailored to the matter at hand. So that's the next slide, actually. Next slide. And so number 8, so proportionality has actually existed in our professionalism expectations. Now we have it in a rule of civil procedure, and be economical and expeditious in your discovery. So that's it for professionalism, but we've been talking about it throughout.
Let me just throw out one thing for professionalism. I did the same thing that everyone else did. I went to the bar site and I printed these out on more than one occasion. I've taught classes on professionalism. It's hard to get your head around the precise details, but folks, there's at least 4 major publications that the bar or sections have put out. The guidelines for professional conduct by the trial lawyer section, the bar creed of professionalism, the professional expectations that Kara was just mentioning. There's our oath of office. I will personally buy a beer for anyone who comes to the bar convention in a couple of weeks and can prove that they have read every single one of these. You're going to have to find me and you're going to have to convince me with verifiable proof, certified that you've done it. Folks, we're professionals. We're not plumbers. We're not used car salesmen. We're not in this to make money. We are in this to be professionals and represent those who need our help. We are the only people that can do that in a court system. We're professionals. We can make money. We can get paid, yes. But our goal is representation, not maximizing income. Read these guidelines. Be professionals. Make this new system work.
And I would just wrap up professionalism with saying that it is the golden rule. If you think about it, how would you like to be treated? At its core, all of the professionalism expectations, and they are detailed, but at their core, it is about the golden rule.
And if you forget about that, just go back and read the rules. Everything I learned in kindergarten.
Yes, yes, same.
All right, thank you to our panel. With our less than 15 minutes left, I'd like to see if we can get through some of our more than
Sure.
300 questions.
Give it a shot.
And these are in no particular order. The first question, I know the conferral rules were discussed, but are lawyers required to meet and confer on spoliation motions and other motions for sanctions?
The answer is, in my opinion, I think you should confer on almost every rule. There's almost no downside. Now, the concept is, if your opponent's going to say no, why bother? And that feeling is in the rules, but there's nothing in the rules that accepts it. Any non-dispositive motion is what the rule says. Dispositive motion is one that ends the case. Summary judgment, judgment on the pleadings, things of that nature, involuntary dismissal. But a motion for sanctions is a non-dispositive motion. I would absolutely confer. It may be pointless, but give it a try.
All right,
Spoliation is not one of those enumerated motions in Rule 1.202. So I think, yes, confer.
all right. Next question, can the scheduling of a deposition be initiated prior to the 60-day initial disclosures?
I don't, under the, that's a technical question. Under the rule as presently written, since the rules do allow initial discovery by setting depositions, technically, yes. In my opinion, that glitch, which says except as provided by these rules, will be eliminated. And within a small number of months, the rule will be finish your disclosures first, then do discovery. And I don't think you can start the process by serving notices during the 60-day period. I think you got to finish your disclosures first. And the problem with that rule is it says that the disclosures must be completed satisfactorily. There is a mumbo jumbo word that's got no legal definition anywhere. And there's going to be more hearings in front of Judge Phillips arguing whether the compliance has been satisfactory. Unfortunately, that's a bad word. The answer to the question is, I don't think you should be able to do any discovery or start any discovery until the completion of the disclosures. If you finish your disclosures with your initial filing or in 10 days or in 20 days thereafter, you're good to go if you're the plaintiff. If you're the plaintiff.
And if you're the defendant, would that include sending out subpoenas for medical records?
I believe so.
I do too.
Okay.
And again, the whole thing is get those disclosures out. The quicker you get the disclosures out, again, satisfactorily, the quicker you can get started on your discovery.
All right.
Exactly.
Judge Phillips, I think this is an appropriate question for you. How do we request the court to rule on the papers? And I'm assuming this refers to a motion for summary judgment. And does the other side need to agree to that?
If you read the case management order, it tells you.
Okay.
Also, if there's any tweaks to it, if you read the judge's policies and procedures, it's in there.
All right.
So, if again, RCMO, and I don't want to take the time to read through RCMO, but it directly tells you how to do it and what to do.
All right. Thank you. Next question. When does a defendant now have to disclose surveillance videos with respect to initial disclosures? That's a very good question.
Really good question. Are they using it for impeachment?
That would
Because
be,
that's the exception in the rule.
That's
If there's an impeachment basis, that would be the only reason. But if it's relevant to a claim or defense and it's not privileged, then you have to disclose it. I mean, there might be a claim of work product protection if you're not planning to use that.
That's an excellent question. I'm quite certain the drafter of that rule did not consider that, number one. Number two, and it's been a while since I did a surveillance issue. There's a case on it. It's a big case. And what it says is you don't have to give it to the other side until you have an opportunity to depose that person and lock them into what they can and cannot do. It is sort of a condition precedent to the mandatory disclosure of that surveillance video. I do not think that the mandatory disclosure rule of 1.280 throws that case out any more than it gives Judge Phillips the right to dismiss cases willy-nilly because someone doesn't show up at the case management conference. So the answer is no. If you have a valid reason to withhold that in the traditional 2024 world because you have not yet had an opportunity to lock in your person who's been surveilled, then I would say that rule continues, that case continues.
And that's impeachment because you don't know whether the person's going to be truthful or not. You may want to use that as impeachment. So I think that falls along with that, holding that back.
And the cases out of the 4th DCA, I just can't remember the name off the top of my head. And also, if in fact you do take the deposition, thereafter, you must promptly disclose it if you
Right.
are going to use it. Remember, supplement, supplement, supplement.
But that is an excellent, there are going to be those fine point questions on disclosures that nobody has an explicit answer in the rule. That's one of them. I think it's an excellent question. I think our answer, the three of us agree, but nevertheless, it's not in the rule. It's a good question. That person gets a beer, see me at the Florida bar.
and one of the earlier questions that I saw that came in, that is somewhere in the stack, somebody had asked if the initial disclosures pertain to BWCs or body worn cameras. I'm assuming that has to do with police liability cases. Does anybody have any thoughts on that? My only thought with respect to that is I know that BWCs are given out when a public records request is sent in. So my feeling would be that if it is in fact a plaintiff who has already requested that via a public records request, it would absolutely have to go on the initial disclosures.
I think you're right. Unless there's some overriding privilege that attaches to BWCs. Of course, I knew what a BWC was. You didn't have to explain it to me. It's a body worn camera. We all know that. But now that I know what it is, I think if it's a public record, it would normally be susceptible to a public records request. Then you don't need to send a public records request. Give me that BWC footage. If, however, there is some rule in criminal practice, and I am not one to talk about that, that gives that some inherent privilege, I think the disclosure rule does not negate privilege that exists for particular documents. You still can preserve your privilege, whatever the privilege is. And I think the answer is, if that's the type of document that the BWC film that is producible routinely, public record, then I think it goes to the disclosure.
And if there was some type of privilege, I would disclose it. I would have disclosed that I have it, but object to producing it because of XYZ. At least let them know.
Yes.
I mean, it seems like it would be, you'd have to disclose it, but just in case, on that outside chance.
Next question. Is it a failure to specifically disclose a witness merely as a corporate representative in initial disclosures, as sometimes we don't know who the corporate representative is going to be?
I don't think you're under any immediate obligation to identify who is going to be your corporate representative at trial. That's off the top of my head. It could be anybody. I think it's, and this is a guess, I'll have to admit, I think it's probably sufficient to say a corporate representative on the topics relating to X.
Agreed.
I could see a really strict saying, well, you got to find out who that is right now. Call General Motors, who's going to, I think that's unreasonable, but I think you have to identify if you intend to use a corporate representative for a topic or a series of topics. I think you need to at least do that.
And again, satisfactorily, obviously, if it's a one-man corporation, then you would disclose that person and you should disclose that person. But again, if it's General Motors, there may be a multitude of persons for the multitude of requests for corporate representative issues.
Good point. Proportionality.
There you go.
We have a few more minutes. Let me see if I can get through a couple more questions. Question, my client was just served and I just appeared on behalf of them in a case that has been going on since before the new year. Do I need to serve initial disclosures as the incoming defendant?
I believe it only applies to cases filed after January 1st, 2025.
Correct.
But that raises an interesting point, because Broward and most courts are going to start that 18-month clock running with the filing of the complaint. A plaintiff has 4 months to serve that defendant and then gets an extension because they can't find that defendant. And so you may be coming into a case as a defendant with 4 to 6 months of your clock having run. Now, I don't know what judges are going to do, but if I were Judge Regensdorf, and thank God I am never going to be Judge Regensdorf, I would give that almost immediate attention in terms of adjusting the case management timeframe. But I don't know what's going to happen. But defendants who get a delayed entry into the case, or maybe they've served 3 defendants and then they say, oh, we got to add somebody else. Now they add a new case long after the fact. Those late entry defendants have a substantial argument, because there's still a rule of general practice, rule 2.545, dealing with continuances. I think it's 545. And it starts off with the rule and says something like, every party has a reasonable opportunity to try the case based upon a reasonable time frame. Now, admittedly, that may be different than what we've got in the civil rules now, but that's the overriding rule. Take a look at the rule of general practice on continuances.
All right. And I think we probably have time for one more question. On initial, obviously, we have a lot of questions on initial disclosures. With respect to initial disclosures, do I need to produce my client's umbrella policy?
The rule says a copy of any insurance policy. It doesn't say a primary or an excess. It says any, which an insurance business may be liable to satisfy all or part of a possible judgment in the action, or to indemnify or reimburse for payments made to satisfy the judgment. So the rule, it says any. And so if there could be an excess judgment, then yes, the umbrella would be implicated in that subsection.
Agreed.
All right.
Yes,
And
I agree.
And I apologize. I have seen a number of questions that have come in with respect to initial disclosures and disclosing experts. Judge Phillips, initial disclosures and our experts. I'm assuming that our experts are going to have to be disclosed pursuant to the trial order and when we've retained our experts. Is that correct?
That is correct, unless you know that you have already hired an expert, and you know that that's the expert that you're going to be using. Again, if you read the rule, it says satisfactorily and what you know at the time, and I can't stress it more, supplement, supplement, supplement. And if you know, even before the time period required in the case management order, disclose that expert. And if it's for example, CMEs, obviously with the 18-month trial track, you're going to want to set those CMEs if you know if you know that there's orthopedic injuries, you're going to reach out for an orthopedic CME. And if you get a date from them, just disclose who you're going to use. But again, it's satisfactorily. You know what you know, and you've got to disclose it.
All right.
And you've got to make reasonable effort and do your due diligence to disclose it also.
I think that's absolutely the safe policy. But remember, the CMO Rule 1.200, and therefore the CMO that's drafted on that, has a specific time entry item in it
Yes.
for the disclosure of expert witnesses. When there is a specific deadline, 6 months out, whatever it is, for the disclosure of expert witnesses, I would take the position, if I had to, that specific controls the general disclosure. I don't believe there's any requirement in the listed categories of disclosure that you have to list an expert, although it does talk about people with knowledge who might testify.
That's correct.
I think when there is a specific provision of the CMO that says you can wait until whatever the deadline is in the CMO, other than the disclosure time, I think you're pretty safe not disclosing a potential expert who may die, or you may change your mind, or something else might happen during that time.
All right.
Correct. In the 17th, the general litigation CMO, it's 120 days before calendar call.
Right.
All right. All right. I would like to thank our amazing panel, Paul, Kara, Judge Phillips, for joining us today. I'd like to thank Braulio and his son, Anthony, for setting this up for us. To everybody who has attended, I apologize if we did not get to your questions. I would imagine that Fort Lauderdale ABOTA is going to be doing a follow-up seminar with respect to the changes that we have discussed here today. So please check our website for that. And I know that Kara has taken the time and she has gotten the case management orders and the uniform trial orders from all of our circuits here. And those are posted on the ABOTA website, which is abotaftl.org. And I know everybody is waiting for the CLE code to put in, and that is 2500382N as in Nancy. And Braulio, if we can put that up or maybe in the chat for everybody. And I'd like to thank everybody one more time.
Can you repeat that number?
Sure. It is 2500382N as in Nancy.
Don't share that with everyone else now, folks. Make them sit through this seminar like you did.
All right. Thank you, everybody. Have a good day.